I always start by thanking Sinn Féin for bringing a motion, and I do again tonight, and for the opportunity to speak. However, my gratitude stops there, because I feel that the elephant in the room is being ignored, and lots of TDs and the ministers indeed talked about the upcoming referendum. And the upcoming referendum, which is taking out two parts of Article 41 and replacing it with a entirely new article that gives absolutely no enforceable rights. It confines caring to within the family, and it seeks to recognise the care that family members give to each other by reason of the bonds that exist between them. I can't describe anything weaker or worse with no enforceable rights. And even worse than that, it seeks to replace two parts of 41, which, and again, I describe myself as a mother, a female T, and a rabid feminist. But I'll take away the word rabid and say feminist. And we look at this article, and all of the time it's been misquoted. And I find myself in agreement with Deputy Murphy. The state recognises that by her life within the home, she gives to the state a support without which the common good cannot be achieved. That's woman. In the second part, it goes on, the state shall therefore endeavour to ensure that mothers, so we have women and mothers, not be obliged by economic necessity to engage in labour to the neglect of their duties outside the home. Do I agree with those words, to the neglect of her duties outside the home? I do not. Do I agree that it's specific to mother and woman? I do not. So what has happened here is you're taking out an article with a concept that's excellent, that no mother should be obliged to work outside the home because of economic necessity. You're putting a line through it, and you're replacing it with waffle that gives no enforceable rights. Worse than that, you put caring within the family and you ignore the state obligation. It is truly shocking, disingenuous, and that all the parties have bought into this is beyond my comprehension. Back in 2006, there have been various entities that looked at changing this constitution, and back in 2006 was the one that appealed to me most. There have been many since 1993 forward. And in 2006, Minister, if you care to look at it, they said replace those words with parent. My preference would be mother or father. And keep that with modern language, without a reference to duties. But you are recognising the importance of parents in a home and the parental work that they do. And a parent's work is not the same as a carer's work, although of course they overlap. And what you should have done, and I hope this goes down on Friday, not to score points with the government, so that we can come back and we can change that article there, keeping the obligation, so no parent will be obliged to work outside the home, and separately insert an article that really gives rights to carers, recognises the importance of carers for our society and the billions that they save the economy. And I'll finish by looking at the Supreme Court case that's pending, that you were fully aware of, that you made arguments in the High Court against the mother, who has to go to court because what Sinn Féin are now talking about, the carers allowance that's means tested. And let me, in my as quickly as I can, a young man who was Down syndrome, and epilepsy and epileptic seizures. He suffers from autism spectrum disorder and developmental delay. He suffers from hypothyroidism, hyperactivity, behavioural issues, repetitive head banging, a condition that must be distressing, and I'm running out of time. His sleep is chronically affected. The High Court judge who held against the mother said, I'm quite satisfied, she said, that it is enormously demanding caring for this man, and that the reduction of the full rate of carers allowance by €85 has had a profound adverse effect on the first applicant and causes significant personal and financial strain to her. Bun agus bar an scéal, the High Court held against her a reduced carers allowance because it's means tested, because her partner earns. And you're bringing a constitution amendment and you're ignoring this, and it's gone to the Supreme Court. And what has the Supreme Court said? They have allowed her to skip the Court of Appeal, go straight to the Supreme Court, because she raises issues of such importance. I'll quote precisely, so I'm not accused of over-exaggerating if I have the time. So, the The court further notes that the present case raises issues of systemic importance for the carers of severely disabled children. And she has to fight the whole way to the Supreme Court. And unfortunately, I think she's a difficult case because it's on regulations. However, she does raise 41, the very article you're going to remove if it's successful on Friday. And if that article is removed, I don't know what the Supreme Court are going to do in relation to that, because the case is partly based on the article that gives rights. And I'll take my chances with the court in relation to the modern interpretation, which Susan Denham said 23 years ago, which Justice Barrington said, and which many judges have recognised that no suitable case, and they're totally surprised by this, has come before them in relation to the direct effect of this article, and they will interpret it as a father or a parent, no obligation to work outside the home.
Thank you, Deputy.